Yes. My Lord, my Lady, we were on legitimate aims,
Yes.
if we may, and I've just taken you to paragraph 26 of Mr. Justice Carr's then was decision in Gallagher, that's tab 12 of bundle 2. My submission is that the importance of the aims that he there summarises is underscored by the particular gravity of the harm that can be caused by this type of offence, including against vulnerable individuals such as children. In the context of this legislative scheme, the Article 8 and indeed the Article 3 rights of victims are in play. There is also the point that there is specific comfort to be given, understandably, to those who are victims and who are the families of victims of serious sexual offences, to know that the police will, at least in relation to the more serious offences, always know the whereabouts of the offender.
Do we have any statistics on how many have gone missing despite this regime?
Not as far as I'm aware, but we will check.
Well, I remember reading press reports to the effect that
some had gone
tabs had been
on.
lost on quite a few, but
I'll
these may be inaccurate.
And the gravity and the consequent duty of protection of the public, not merely interest but duty of protection in certain circumstances, have long been acknowledged. The Forbes case is perhaps as good a place as any to see that. Bundle 3, tab 24, if you would. This is a duty recognised by Strasbourg. This is the judgment of the Court of Appeal in a case involving the importation of pornographic material. It focused principally on the automatic application of the regime that we're concerned with. And the argument in summary was that it shouldn't apply automatically to someone who alleged that they didn't know, and it wasn't part of the ingredients of the offence to prove that they knew that the material that they'd illegally imported was pornographic. But the purpose I'm taking you to it for at this point is paragraph 14, which cites a section from the Adamson and the United Kingdom judgment, which was one of the two United Kingdom cases on the regime that have gone to Strasbourg, and the point about both about the gravity of the harm and the duty under the Convention to take protective measures is in the second part of that quote at the end of paragraph 14. The source of the duty that is referred to is the case which is cited in the Adamson judgment, but in this quote at least appears, or should appear, where the dots are in the second line of that second half of the quote, and it's Stubbings, which I'm sure the court will be familiar with.
But Stubbings is referring back to X and Y in the Netherlands, isn't it?
I'm not sure whether it is in this respect.
Well, don't worry.
My lady may well remember that. Let me just turn up the passage and I'll tell you that. My lady's memory is impeccable as always. Footnote 56, it is. The relevant paragraph in Stubbings, it's paragraph 62. Stubbings is at bundle 5, tab 44, and the relevant paragraph in the court's judgment is 62, and says, don't need to turn it up, sexual abuse is unquestionably an abhorrent type of wrongdoing with debilitating effects on its victims. Children and other vulnerable individuals are entitled to state protection in the form of effective deterrence from such grave types of interference with essential aspects of their private lives.
You say that a legal system which didn't have this in it would be in breach?
No, I don't go that far because there are a variety of ways in which protection which is effective can be provided. What I do say is that this is part of the regime which Parliament has judged necessary for the purpose of ensuring that that positive aspect of the duty on the state under Article 8 and perhaps also under Article 3 is complied with.
We had a Scottish case in which that duty certainly was referred to by somebody or other, a devolution case, as part of the reasons why some disapplication of traditional Scottish approaches to evidence was appropriate.
Yes, that might have been.
In order to afford effective protection to the
That would be
victims.
DS.
Yes.
That was DS and HM Advocates, yeah. Which I don't think is in the bundles, but we've got a copy of it here if you need it. Returning to Forbes, there is, and there was in the Court of Appeal in Forbes, specific focus on the protection of children and the compliance with our international obligations in that regard. If you go back to the Forbes judgment, the point is dealt with at paragraphs 17 and 19, in particular paragraph 17, which refers to Article 19 of the United Nations Convention on the Rights of the Child, and is referring to the broader objectives in the context of protecting children specifically.
You're not asking us to draw a distinction between offenders who have child victims and others, are you?
No, I'm not. I'm just illustrating that in the context of children, the need for effective protection has been widely and long acknowledged. Indeed, you'll appreciate that my case is going to be that the regime does and legitimately does apply equally to both types, with nuances to take account of it. But
as a matter of interest, were both of the victims in the two cases that we have children? We know one was, we don't know the other.
we don't know in relation to the other. I've no idea, I'm afraid. That was part of the reason for wanting to find the sentencing remarks, to see whether the daughter in question was or wasn't. We know that one was and was very young, but I'm afraid we simply don't know the age of the daughter. Perhaps the final point on the legitimate aim, or that's very much a tail-end point, is that it's a point that was made rather clearly by Lord Turnbull in paragraph 45 of the A and the Scots Minister's case, that when considering the legitimate aim, and particularly when considering the various balances which will need to be struck when we come to proportionality, it is at least relevant to note the conduct of the perpetrator. It is, after all, the perpetrator who has put himself by his conduct within the reach of this scheme. And one can't simply focus to the exclusion of all other things on the consequences for the perpetrator.
That's a point of distinction from L, isn't it? In the L case, let's take particularly the case of a malicious allegation which finds its way into the police notebook, and she's applying for a job. And there was some discussion. I think Lord Scott felt that
Consent was all.
he thought that they'd brought it on their own head, but I think the majority view was that that wasn't so, that it was an inescapable fact. If you apply for certain types of employment nowadays, you have to have this enhanced police check.
And again, I think that from memory, that was another point of distinction between the positions of the Home Secretary and the police, where the police's position was the rather starker one, which Lord Scott was attracted by.
Yes.
And the Home Secretary's position was that it was a relevant factor, but not a conclusive one. Mm-hmm. But my Lord is right. I will then the proportionality analysis. Perhaps if one leaves open the Forbes case, because we may need to go to it on a couple of occasions in the context of a proportionality exercise, and starting with the nature of that exercise. The broad nature of that exercise is conveniently summarised in the passage that I've just referred you to, in paragraph 14 of Forbes, and the quote from the Adamson decision. You'll see that in between the two limbs of the quote in paragraph 14, the broad balancing exercise that is required by the proportionality exercise is summarised by the President, where he says, after examining the effect of the notification requirements, the court balanced the burdens imposed on the applicant against the importance of the aims pursued by the Act. And that is indeed the exercise and approach which the court took in Adamson.
When one's looking at the question of proportionality and necessity, one aspect of this must be the efficacy of these particular measures. Is there any data at all? They've been now in place for some while in one form or another, as to the extent to which they assist in apprehending repeat offenders or deterring repeat offending.
Again, I will check to see whether there was any evidence below on that. I can't recall any evidence. I don't think there's any in the appendix on that front. Of course, one may need to be a little cautious. I suppose one could do a comparison of before and after, and the statistics before and after. But whether they would provide a sure or reliable basis for a conclusion one way or the other might be a matter more debatable. But I would check to see whether there is outside the material that was before the lower courts any material of that kind.
In that passage you referred us to from Adamson and so on, did the European Court go into evidence? It just talks about the aims and so on, pursuing legitimate aims.
It doesn't appear to have done. If one goes to the Adamson decision, there was some summary of the nature of the regime, and there will have been no doubt some legal argument, but there wasn't an extensive analysis of evidential foundations and so on. They looked at it much more broadly than that, struck a balance and determined that this was a regime which passed muster. But there certainly wasn't, even in the recitation of the facts, any detailed analysis of those issues.
My impression is that they don't usually do that.
No, but they will rely upon whatever evidence the domestic courts have had and so on. So, but they felt able, and it's a point that can be made fairly, they felt able in the Adamson case to reach the judgment they did, albeit on the rather more broad brush approach.
Yes, exactly.
Simply weighing up the benefits and the disbenefits, the effect or the potential effects of the legislative regime, and then balancing that against the obvious, that might be thought obvious, potential benefits of knowing where these people are. Just in terms of the striking of that balance with on the one hand, the effect on the individual concerned of being subject to the regime and the legitimate aims that I've gone through, it is perhaps worth noting that in the Gallagher case at tab 12, paragraph 24, Mr. Justice Cardigan was judgment there, he said that the gravity of sex offences and the serious harm that is caused to those who suffer sexual abuse must weigh heavily in favour of a scheme designed to protect potential victims of such crimes. That we respectfully endorse. So in terms of the general analysis at least, the proportionality exercise involves examining the scheme as a whole to see whether it strikes an appropriate balance between the respective interests that are in play, and to see whether it does or does not go further than is necessary for the purpose of achieving that aim. It is the standard proportionality exercise. We do, however, note that in this sort of sphere, it is appropriate, we do submit that it is appropriate to accord appropriate respect to the judgment of Parliament that a scheme of this kind is necessary. I'm not sure I took you to it, but there was a passage in the L decision that we went to this morning in the speech of Lord Neuberger, That's in bundle 4, tab 36, which it might just be worth turning up briefly in that context, because although there are differences on this point, the schemes are sufficiently similar for the same approach, at least, we submit to be in play. Tab 36, paragraph 74. These are considered legislative decisions in terms of assessing the degree of respect. My first suggestion is that these are considered legislative decisions.
Can you have an unconsidered
Yes.
legislative decision?
But by that I mean that at least some of the aspects of the scheme, and in particular whether or not there should be a review or an appeal, were matters which were specifically before Parliament. Sometimes, for example, in the context of voting rights for prisoners, it said, and there's a matters that was relied on which Parliament hadn't actually considered a matter against it. Here at least they have considered very specifically whether or not some aspect of the scheme should or should not be in place. Keep referring to that academic article.
Well, the version I have in my bundle is virtually illegible.
Well, let's see if we can't get a better copy.
What is the...
Bundle 11,
Under 11. Okay.
tab 113. I'm not going to delve too far into Hansard or the consultation documents. I'm at lunchtime hopefully we will have it has a lovely clip of potential relevant Hansard and the consultation paper which preceded 1997. And maybe it goes to addressing on that. Tab 113 in bundle 11. And the relevant page is 261. About 259. Under the heading lifetime registration. Second paragraph. Attempts were made to amend the bill during the passage of Parliament to allow variation in revocation of time period. If a person's risk assessment changed in the form of appeal, people on the registry thought they could be safely deregistered. On the appeal, the amendment was worded. The person who is subject to notification requirement under this part may appeal to the County Court of Scotland, the Sheriff's Court. No longer be subject to such a requirement in the court may make such an order. Where it is of the opinion the person making the appeal is no longer likely to be a danger to others, and that it is in the interest of justice to do so, the amendment was not accepted and eventually withdrawn.
This must be in the 1997 Act.
This was 1997. For relevant purposes, the provisions of the 2003 Act are repetitive.
Yes, yes.
Of course, it's one thing to say that it's impossible to determine at the time when you impose the order how long it may be needed for, and another thing to say that there should be no possibility of ever reviewing it.
There are two separate things, and that is in large part why the nature of the evidence for continuation of risk.
Yeah.
Which is obviously something.
Yes, but of course that is purely general evidence.
But it is the best evidence that is available on that there is continue to have a reach no risk. Of course, there are questions of degree involved, and of course, I accept that in certain circumstances where the consequence for the individual is that much more severe, such as whether or not he should continue to be in prison, the parole board would have to grapple with issues of risk of reoffending in the context of deciding whether or not release was appropriate. So there are circumstances in which the current criminal justice regime already requires, not merely permits, but requires courts to grapple with that issue. But that is, in a respectful submission, very much tailored to the fact that the consequence of the individual is detention. Non sequitur that the same result should follow, i.e. there should be the same opportunity whether the regime in question and the consequences of risk need not to continue detention but to some considerable level, such as notification. But that academic argument, at least a rather roundabout way of showing that what I meant by the
There's also a reference on the facing page to the consultations that had led up to the 97 Act.
well, I suspect.
If I can read them, that's what it seems to be.
Yes, the best source of that is likely to be the original source, which is the consultation paper itself. And I'm aware there is a copy which will have been
We don't quite know what the Minister's answer was to the point on page 260. The quote from the Home Office consultation document.
Well, his point of flexibility creates the possibility of an individual having to go on reporting cases of address for decades, including moves from a residential home for the elderly to a hospital or hospice. We don't know, the Minister doesn't condescend to any particulars as to why some exception wasn't made for that example. Just to take one quite large group, or potentially a large group.
Well, I don't know without
Especially in these days of ageing populations.
We are referred to the full debate on all the columns there, but
I don't know whether,
we don't
without
know.
going back to the source material, I don't know whether he's provided an answer.
No.
Certainly,
What would his answer be? I mean, always counsel.
his answer would presumably be that it is
It's okay and just, is it?
it is a necessary part of the.
Not necessary for people in a hospice to, or in hospital.
Well, it's a necessary part of the regime to be set up so that it has clear dividing lines to apply to all people who are convicted of
Except those sentenced to 29 months.
It's still a right for them, it's a right for less activity. And the point is.
And presumably the logic of having a cut-off at, say, 30 months is because the risk is regarded as acceptable. Now, if that risk is regarded as acceptable, it's unclear to me how logically, or as a matter of principle, that must surely follow that it's true of a whole series of types of people in the first category.
Well,
And examples of those, or some examples of those given in that little quote.
that's a point you made this morning. Of course, if you set up a scheme of any kind which draws those types of lines, you will end up with difficult cases on one side of the line or the other. And this court, on a number of occasions in a number of different contexts, has had to consider bright line rules, bright line setup. I'm not going to go trawling through that line of cases again. They've been very extensively trawled in the helpful sections of the Lord Advocate. But in a number of different contexts, one does end up with, as it were, hard cases to justify if you're the day before or the day after a regime applies. And ultimately, those are legislative judgments that have got to be made.
Yeah, but my point is that the underlying basis for the line, and I quite follow your point about bright lines, and you've got to have lines, is because of some sort of assessment of the risk has been taken. And you say you have a bright line, which is a fair line, having regard to all the various assessments you make of the risk. But if you are doing that, if you're applying such an approach in relation to the bright line in one context, it seems very peculiar not to do the same for the people who were convicted decades ago.
Well, I think that simply comes down to whether or not it is legitimate for Parliament to have concluded that the appropriate mechanism for achieving that gradation or that calibration is by reference to the seriousness of the conduct. And one view is, I would say, well, looking at the evidence, shouldn't all sex offenders be subject to this indefinitely? But it might be thought
It must be the seriousness of the risk, not the seriousness of the conduct.
well, say the sentence is reflecting the seriousness of the conduct, and Parliament has decided that it is.
Well, the sentences, but this what you call administrative scheme is about the seriousness of the risk. Now, I quite follow that the seriousness of the conduct is an important factor in deciding what the seriousness of the risk is, but the essential question is, what is the seriousness of the risk?
Well,
because that's what you're trying to protect.
yes, but don't jump too far ahead in the submissions, but it might be thought that isn't an entirely accurate way of presenting the essential question. The essential question that might be thought, given the nature of this regime, is whether or not Parliament could legitimately and rationally have concluded that there will be some risk. And if there is some remaining risk, then it remains appropriate in relation to those who have been convicted for the most serious offences to be subject to this regime for very considerable court time.
I mean, you might assume the risk was the same, but the risk of what? I mean, if a person has committed a very violent rape or something like that, then I would have thought Parliament might take the view that it was worth protecting against that, the risk of that violent conduct occurring for a longer period than of some relatively minor sexual peccadillo, even if the risk of a sexual peccadillo or sexual offence occurring in the future was exactly the same.
That would lead to a scheme which was graded according to the offence itself.
Well, that's what this is, presumably. You get 30 months, or not because it's just the same conduct as you get 6 months for, but because it's more serious, I would have thought.
Yeah. Well, that is the basis on which it's done. As I say, one can make a logical case for saying at least if there is some risk, it should apply throughout the lifetime, irrespective of the seriousness or otherwise of the offence. So Parliament has also decided that the more serious the offence, the longer the regime should apply. And respectful submission is a discussion of the But still on the respectful Parliament's judgment point, all the cases to date that have considered this scheme have concluded that this is an appropriate area in which respect is to be accorded. So I can just give you some citations. All that we will look at on a number of occasions. Perhaps I need to turn it up for this purpose. Bundle 3, tab 24, paragraph 18, where the Court of Appeal said the legislative decision must be afforded what can previously be summarised as a broad margin of appreciation. Gallagher, bundle 2, tab 12, at paragraph 20, relying upon a very, very well-known passage from the speeches of Bingham and Brown and Scott. And noting in paragraph 20 of Gallagher that the scheme was both introduced by a democratically elected parliament in terms of the primary legislation, and also that the regulations, it's quite a major reference to section 1 that the regulations that were to be made, depending on the relevant part, required the approval of both houses on the terms of those rules.
What's the paragraph reference in Gallagher?
Paragraph 20.
No. No. Thank you.
The Marker case in the House of Lords, bundle 2, tab 17, paragraph 33, final sentence. to tab 17, para 33, final sentence. The legislative choice must be approached with due deference to the policy decision made by Parliament. And then A and the Scottish ministers will return to the document Article 3, tab 29. Collect a number of references on the same theme, both domestically and also in Strasbourg. Strasbourg has recognised the breadth of the margin.
But these are two completely different concepts. The margin of appreciation that Strasbourg allows the United Kingdom in making certain judgments where latitude between different states is recognised in Strasbourg is a different concept from what the courts of the United Kingdom may say in relation to recent democratic decisions.
I entirely accept that. That is a point that was made perhaps most forcefully, most recently in the G case.
Yes.
And the point that was being made there is that Strasbourg takes into account a series of factors in arriving at the principle of margin of appreciation which have no application other than on the international plane. The reason that the two are often, perhaps analytically incorrectly, at least set alongside each other is because they are not dissimilar in terms of their effect. They may not be identical, but they're not dissimilar in terms of the effect. They accord to the relevant decision maker on the one hand, margin of appreciation, appropriate degree of leeway, where there isn't a single right answer to a problem of a social kind. So I entirely accept my lady's point that the two are different, analytically distinct, but nevertheless they do have some at least equivalence of effect.
I think I made that point in Kebeline a long time ago, didn't I?
You did, when you described that as a discretionary area.
Yeah, but I think I made the point that they were different things, but there was a similarity between them. Is there a paragraph, particularly against Scottish ministers?
Yes, paragraph 48. So maybe just as well we've had the discussion we've just had, because not in the same paragraph, perhaps analytically incorrectly, are both domestic authorities.
Well, one of the problems with G, as unfortunately we now have to call it, because it's sitting in my head as P, which is what it was when we decided it, was if something is within the margin of appreciation, how does that affect the power of the court to say to Parliament, you've got it wrong?
Yeah.
And in G, we thought either it would go a particular way in Strasbourg, or it would be within the margin of appreciation. We had different predictions as to that. But either way, the result was we were prepared to tell the Northern Ireland Assembly that they'd got it wrong. That was what we were struggling with.
And in the end, as I recall G, the essential analysis was to ask the question, domestically at least, whether there was a rational basis on which Parliament could have concluded.
Oh, that was undoubtedly the reason that however big the margin of appreciation, what you do still got to be rationally connected to your legitimate aim. So although that's not sitting there in your little quote from Adamson, that is an important part of the proportionality analysis.
This was the appropriate place to strike balance, in fact. As I understand G would be, the essential problem was you couldn't reach that conclusion.
If you were committed to doing the best you could for the particular child in front of you, there might be cases in which allowing that child to be adopted by an unmarried couple would be better for that child than not allowing the adoption.
Precisely, and irrational because the scheme itself required the best interests of the children to be taken into account, and therefore it became, as it were, internally incoherent if you then said, well, actually, there are circumstances where unmarried couples might be by far best in the interest of the child. You can't do it at all.
Well, this is why we're exploring with you whether the content of this scheme is rationally connected to the legitimate aims which you are positing for it.
Well, the rational connection the rational connection piece is very much, as you will see when you go back to Scottish ministers, I'm not going to go through the entirety of the judgment of your oral submissions, but you will see that what Lord Turnbull has done in the Scottish ministers' case is very much to follow the approach, which is an alternative way of doing the proportionality exercise, set out, I think, by Lord Clyde in the Freitas,
Yes.
which I think is the high watermark of that, in terms of emphasis on the paragraph 48 of the paragraph on which we relied for the purpose of there being a domestic in our context. The mission is that conclusion by Lord Turnbull is also right, obviously right in principle in our context, because one is in an area where there are difficult legislative judgments to be made about, for example, the nature of the risks in a particular area, what is required for public protection in an area where the evidence of and so on are far from clear. One is in an area where at least there is a question of whether or not Parliament is entitled in those circumstances to adopt a precautionary approach. And so we are going to continue the scheme for a long time because the risks continue to disappear. And there are questions of judgment about the effectiveness of the protection and the nature of the regime that is required to deliver that. And on each of those areas, there is, in my respectful submission, no right answer. There are a variety of different policy options, if one wants to look at it that way. And that is, therefore, fertile territory for the application of the doctrine of respect. Also for the additional reason that one is in territory where Parliament is in effect striking balances between interests which are a variety of sets of interests requiring those of the offender certain efforts equally and powerfully uses in the context of the position of the victim. That's the legitimate aim and proportionality exercise. In terms of the burdens imposed on those who are subject to the regime, which is one half of the balance specifically referred to in Gallagher and Paddington. I don't much want to get sucked into a descriptive debate, because it might be thought to be terribly profitable. Whether or not one describes it as the effect or impact of the regime in Scotland or in whether one describes it as an inconvenience or as a considerable inconvenience, as described by Carr in Gallagher, 1926, or whether one describes it as imposing quote, significant burdens upon those who are subject to the regime, and then goes on to state they are intended to do so, as the President did in the Forbes case, 1 to 3, tab 24, paragraph 10. Matters less than your judgment about what the regime does actually import in terms of hardship to the individual. As far as that matter of substance is concerned, I've tried to take you this morning as conveniently as possible, expected through the complexities of the regime as it applies both here and across the northern border. There's a number of points perhaps to note about that. First of all, the regime is not in the nature of a punishment, and nor is it part of the sentence of the court. This point was expressly made in the Scottish Minister's case 45, but relying upon the House of Lords judgments in Longmouth, Bundle 3, tab 21. I wasn't going to go through Longmouth in any great detail. That was the case about whether or not conditional discharge should trigger the regime. The short point here is not a punishment and not a part of the sentence. Secondly, in terms of the substance and effect as I've acknowledged a moment ago, one may need proportionately to reach different levels of judgments about the balance between the various rights in play where liberty is involved. One may have to do the best that one can in that context to assess the precise levels of risk. One might have to put up with, put it that way, something less than the absence of risk. One might have to put up, in terms of liberty decisions, with low risk, for example, manageable risk. Doesn't follow that one has to put up with low, manageable risk, if there is such a thing, where the impact of a regime is commensurately lighter. Thirdly, in terms of the substance, it is, I say simply, a duty to provide information. That information is provided to enable the legitimate aims of public protection through prevention, detection and deterrence to be effective. All the things that you're required to do under the regime are known as specific are rationally connected to the aims on which is to use that language. They serve to assist in promoting the effectiveness of the regime and the effectiveness of the achievement of the aims. And fourthly, a point made in Scottish ministers, although it may need a little nuancing perhaps, in order to be entirely accurate. A person who is affected by the regime is not prevented from doing anything. So that was the rather bold statement in paragraph 45 there in the Scots ministers. And it's to be noted, first of all, under that heading, that there are a range of options under part 2 in the sections that we didn't go to, but that follow the sections that we did go to, which govern a series of regimes that do allow courts to say, thou shalt not do this, thou shalt not do the other. Foreign travel orders, for example, you cannot go abroad if there is, for example, there are within part 2, there is within part 2 a series of regimes that do impact directly on what people can and can't do. Now, I said it needs a little more in order to be entirely accurate. There are, of course, and I acknowledge there are, of course, some instances in which the operation of the notification regime may indirectly impact on whether someone can or can't do something.
You accept the examples listed at the back? I think it's the response case. Yes. Yes.
Follow from the fact that one might have situations where you couldn't give notification in time.
Right.
All of that ilk.
Yes.
And if you assume, it's a little hard to construe the entire context, I think it's regulation 5 is the one that deals with travel notification, what you've got to do. But in essence, there is a 24-hour cut-off. You can't travel unless you've given 24 hours notice. And if that is the position, then the necessary consequence of that is that there may be some cases where shorter notice enough where one simply can't do that. But they are.
Well, it's coupled with the requirement for you actually to attend personally at a particular police station, which obviously makes that a much more difficult thing to do if you happen to have certain types of employment where you aren't anywhere near that police station and you've got to drop everything and go somewhere.
Those examples could no doubt be put. So I don't put the case perhaps as high as the or as bold as the statement of paragraph 45 there in Scottish ministers, and do acknowledge that there may be some instances, but I do say that those are, as it were, indirect effects, and they are effects that flow from what I would submit is a necessary part of the scheme. You can design the regulations rather differently, and that probably we focus making earlier on. That doesn't touch the heart of the scheme, but they are all incidents of the effectiveness of the regime. So the 24-hour notice period is designed to provide police with a sufficient opportunity, at least, to take whatever steps they feel appropriate to take in certain circumstances. An advance warning of some kind of an intention to travel is a prerequisite for the taking of, for example, steps to secure urgent foreign travel restraining order. So to the extent that there are indirect effects which flow from parts of the regime which are necessary for its effectiveness. I don't shy from the proposition that there are certain circumstances in which those sort of indirect effects might arise.
What are these things called? Sexual offences prevention orders? I mean,
that is one type of order.
yes, but what do they do? I mean, they can prevent you from, prohibit the defendant from doing anything described in the order. What is that? I mean, what is it?
I think going into a particular
Area, is that the kind of thing?
that's the kind of thing.
Yes, thank you.
Perhaps for your notes, if you're interested in that side of it, there are effectively three types of order in the remainder of Part 2. There are firstly sexual offences prevention orders. The relevant provisions there are 104 to 113, and the nature of that piece you see from 117. So 104 to 113 is sexual offences prevention orders, and the nature of them is 107.
107.
107. Secondly, foreign travel orders, which do what they say. 114 to 122, and their nature is at 117. And further, the risk of sexual harm orders, 123 to 129, and their nature, I think, at 125.
So these can be looked at one way as being burdens on the imposed on the person, but on the other hand, I suppose they could be looked at as ways in which this regime does actually contribute, or may be thought to contribute rationally to preventing sexual harm and so on and so forth.
Well, that is an entirely fair point. It's a point which I'm going to come back to, because it's a point which can be put rather more broadly. You will appreciate that there are a variety of different, as it were, interlocking or interplaying regimes in the present context. There is obviously a balance, as it were, between the notification regime and these sort of substantive orders, which is the point that my lord is on. But you will also be aware that alongside this regime there is the Rehabilitation of Offenders Act, which I can come back to, and the periods in this act almost identical to the periods in the Rehabilitation of Offenders Act. In particular, the 30 months and over period is the same for indefinite. You don't get rehabilitated if you're over 30 months. So there's a mirror between those provisions. But there is also the retention of information about convictions. So there's a block out there, so that one has on the police national computer, legitimately under the Data Protection Act, a series of particularly serious offences for 30 months and over. Those will be on the PNC for the lifetime of the individual. And these notification provisions, therefore, don't merely play into the other Part 2 funds, don't really play into the other Part 2 orders that one might be able to go off and get. But they provide, as it were, the essential wraparound to the use of that information. Conviction information, so you can hold the conviction information, and what the notification regime is designed to do, is to give some practical punch to the potential uses of that information. So my lord makes an entirely fair point about Part 2, and I broaden it out to include the conviction information. My lord, just before I get on to the central issue, which is why no right of review, can we just touch briefly on the automatic nature of it, because there are some points which feed rather more generally from that. I know that part of the challenge is indefinite period and no right of review. Is it worth picking up the automatic aspect of it? Because the two are very closely interlinked, and the same points play into those. There isn't such a sharp distinction about the appreciate from the legislative regime we looked at this morning that the consequence of being sentenced to a sentence of 30 months is that the indefinite period applies, indefinite notification period applies. That applies across the board. We had some discussion talk about that. It applies across the board. So, as has been said in past cases, that's insufficiently focused on the individual circumstances of particular cases and is disproportionate to that separate. That isn't the focus of the challenge now, but I should at least pick it up. The scheme in legislation, in my submission, is set up and deliberately set up so that it is of general application in that way, as opposed to being set up so that it all depends on the facts of the individual case as to whether or not you're subject to the regime, and if so, for how long. However, that in my submission plainly doesn't render the scheme objectionable or disproportionate. First of all, it is clear that there is calibration within the scheme itself. See on that point, A on the Scottish Ministers again, I'm afraid, bundle 3, tab 29, and paragraph 49. That was one of the grounds of attack that the scheme applied generally. It said, no doubt in a deliberate echo of the European Court of Human Rights and Western Marlborough, that the scheme applied generally in indiscriminately a blanket fashion, and the only judge rejected that. But in my submission, he was right to do so. Calibration in the Act is focused on individual cases, but is based on the seriousness of the offence, as reflected in the sentence. And the different periods are then set out on that basis, some finite, and the most serious and indefinite. And it's the point I made a moment ago, that there is, in that way, as it were, by setting those periods, there is coherence between legislative regimes. Those periods are based on, or taken from, the Rehabilitation of Offenders Act provisions. As I emphasise, that in itself needs to be seen alongside the fact that the police, by virtue of a separate regime, retain conviction information for very long periods of time. And so one would expect, as it were, there to be a match between those regimes, particularly if it's accepted, as it appears to be, that the 2003 Act scheme is centrally designed to ensure that one can achieve the public protection aims through prevention and deterrence. And it would lead, it might be thought, to a very odd mismatch if the police had access to the computer and were able to access it to say, well, that person was convicted on X date and Y date, and that was the offence and that was the sentence, but then had no idea where the individual was. That would be a very strange and perhaps might be thought incoherent way of achieving the requisite public protection. There's also, and I don't need to go through this in any detail because we touched on it this morning when we were dealing with the regime, it's also evident from the face of the legislation that it's calibrated to take account of the position of young offenders. So they are subjected, for good or ill, to half the finite periods in Obligation 3.2. And although in relation to the finite periods, the 30-month trigger, 30-month detention sentence trigger, is the same, that will in itself, a sentence of 30 months on a young offender, will in itself take into account the fact that that offence was more serious. That point, perhaps the best statement of principle is in H and Bequeen, which is in bundle 2, tab 80, bundle 2, tab 28.
Can it be bundle 2?
Bundle 3.
Yes.
tab 28, paragraph 18. And then we put the bit in brackets. Short point being that if a young offender gets 30 months, it's a jolly serious. Calibration, even though there appears on the face of the indefinite regime to be a uniform 30-month period, that 30-month period is uniform because it already and inherently takes into account the usefulness of the offender.
Is it still the law that a sentence has to be discounted really quite heavily, by as much as a third, I think, if somebody pleads guilty at the earliest possible time or whatever, or varying with how soon? So it's not only reflecting the seriousness of the offence, it's reflecting the speed with which the person owned up.
Yes, it is, but it might be thought that wasn't such a case in the present context where, as my lady would have seen from the expert reports that followed in the appendix, the rehabilitation, or reintegration, and all the programmes that were designed to assist with that start with an acknowledgement of the offence.
However, also, the report says there is no rational connection between denial and risk, for fairly obvious reasons.
One of the categories of whether the denial is.
Or the fact that people won't start working with you to make you understand why what you did was wrong until you've admitted that you did it, that's a separate fact from the relationship between the seriousness of the offence and the degree of risk, and whether or not you owned up. That's all.
Mr. Reader, it's my fault, I'm sure, you've probably told us, but where do we find, where does it lay down about the retention of previous conviction information, and where does that, because you're referring...
In the legislative, I think we've covered that all in the bundle before. The regimes which govern that. There is an information commissioner decision in the bundles which considers.
Is it in?
Perhaps you could give us it at some
Yes,
point,
yes.
so as we can just tie it down.
To show you
Yes.
where that is and what it bases. That's the decision is at tab 37, bundle 4. We'll do you a short note on the legislative structure.
Presumably, once information is given under this regime to the police, then it is retained, even if for a young person or something says less than 30 months or so the period expires. Nevertheless, the information they have got is retained thereafter.
Yes, it is, and it's a point, I think, from memory, and it may be retained after the period to some extent, comes to an end, the notification period comes to an end. But obviously it will rapidly be growing in terms of its development, and it may go out of date and new person, so the purpose of it is to have it current. That point is made in 4, bundle 3, tab 24. Paragraph 12.
Sorry, where are we?
We're on the point, does the information which is given to the police
Yes.
survive beyond, and is it retained beyond the notification regime's operation?
Yes.
Answer, yes. Acknowledged in forms. See bundle 3, tab 24, paragraph 12. Is that the point I will remind you?
Yes, that was good.
I was just actually looking at H against the Queen, was it?
This one's in,
No,
this one's in forms, which is tab 24.
Yes. No, I was looking at the Information Commissioner case, and paragraph 23 does talk about the Police and Criminal Evidence Act and the PNC and all that kind of thing. Obviously, I have to provide a note to bring this together neatly for us, I think.
And that would be like one of the convenient form that referring it to adjustment.
Yes. Yeah, thank you.
my second point in relation to the automatic application of the regime is that subject to the calibration which is in the Act, it is and was legitimate, or to use the approach in G or P, whichever one chooses to call it, rational for Parliament to judge that the rules should apply in these categories. So to draw bright lines, as it were, in the places in which it has. This regime, I submit, and I can do it shortly because we've touched on it already, does not suffer from the sort of inherent no rational connection defect that the scheme that was being considered in P/G suffered from. Parliament no doubt could have made the scheme entirely discretionary, or put it entirely in the hands of the court, but it didn't do that, and chose not to deliberately. Because it judged, in my submission, entirely understandably and rationally, that it would be beneficial in terms of the aim of public protection to have clear categories. All of those who are convicted of such offences are caught, and that maximises the protective reach of the scheme. And it ensures, by setting the lines in that way, the broad categories, of course, I mean, that was done before and after, you do end up with a consistent coverage rather than a disparate regime where courts decide falls within and the other one doesn't. So it does lend itself to the drawing of lines. Wanted perhaps the best justification, or the prettiest justification for drawing bright lines in this sort of context is perhaps in Bingham's speech in the Animal Defenders case. Or tab 31, paragraph 33. Well, against that background then, can I turn to the why no writing review on the indefinite regime aspect of the scheme? That aspect of the scheme has been specifically considered in a variety of cases, both domestically and in Strasbourg, in relation to this particular scheme. So in Adamson, Bundle 5, paragraph 47, Mr. Adamson was subject to the indefinite regime. Massey and the United Kingdom, which followed Adamson, Bundle 6, tab 51. He was also subject to the indefinite regime. It is perhaps worth turning back to Bundle 6, tab 51. We've seen that this positive quoted from Adamson on a number of occasions now, both quoted in Gallagher and quoted in Forbes. Massey, we haven't seen Bundle 6, tab 51. Tab 51.
This is no limitation period on bringing criminal proceedings.
Yes, he made a series of complaints.
Yes.
If one goes, and some of them don't need concerns at all, if one goes to page 9 of the report, second and fourth paragraph on that page, you'll see, well, perhaps it's at the bottom of page 8, illustration of crime on the Sex Offenders Act and so on. And he was himself subject to the indefinite notification regime period. And you'll see the penultimate paragraph in that little section for a person over on page 9, second full paragraph, for a person who has been sentenced to a term of imprisonment of 30 months or more, the registration requirements are indefinite. So Strasbourg was focusing on the equivalent to the 2003 scheme, identical in the 1997 scheme in this respect. And is plainly aware that if you fell over a 30-month or more if you were sentenced to 30 months or more, the regime was indefinite. And their right of review, it had the legislation before it, so assumed to be unaware of that. Even clearer, if one goes down in the complaints section, you'll see that there is complaints being made. Second paragraph of the complaints section, on that same page 9. And if one picks it up about 6 lines up from the bottom, he also complains that he is subject to the registration requirements under the Sex Offenders Act 1997, and that there is no assessment or review of the necessity of registration in this particular case. So not only did Strasbourg have, as it were, the indefinite regime before it, this was a case in which they were considering a complaint about the indefinite regime. It can hardly be suggested that Strasbourg was unaware that there was no right of review. They simply used the shorthand indefinite when describing the regime above, and they referred to any right of review. And when they come to the complaint itself, the nature of the complaint is not merely that there wasn't an assessment, which very naturally was referred to in final sentencing, but also that there wasn't a right of review, i.e. an incidental feature of the thing being indefinite. So they were, in my respectful submission, clearly considering that aspect in the face of a complaint that there was no right of review. And their conclusion, on page 12, which paragraph Roman 3, which is the relevant one for our purposes, is of precisely the same reasoning that led the court to reject the complaint in Adams, applied also in identical terms to lead them to reject. Now, it's fair to say, and it's right to point out because the Court of Appeal placed some reliance on it, fair to say in relation to Adams that the nature of the complaint was rather that the nature of the specific complaint, as recorded, was rather less clear. Query, was he just complaining about what I call the automatic application of it, or was he complaining about a lack of review after it had cut in? But there can be really very little doubt that on massive, they are considering the absence of any review in the context of the indefinite application. And they reach the same judgment directly on this scheme and on this part of the scheme. So we do submit that this, coupled with Adams, in certain case, is directly applicable to Strasbourg authority. In effect, clearing the legislative scheme of proportion and the broad reasoning there set out. Effectively, this is directly from Adams. And unsurprising in those circumstances, that Mr. Justice Carty then was in Gallagher, reached the conclusion that he did, just to go back to paragraph, to volume 2, chapter 12, the Gallagher case, for a moment. He also, this is moving from Strasbourg into the domestic regime on this actual review. It's to be noted in the context of Gallagher that he himself was subject to indefinite notification. As one sees from paragraph 1, see the effective total sentence in the final sentence of paragraph 1. And you'll see that the specific complaint that was made was about the lack of an opportunity or a possibility of review during the operation of that indefinite regime. See the final sentence of paragraph 13. And it was that complaint that was disposed of by the reasoning which led up to the dispositive paragraph 26. squarely raised the precise point. A and the Scottish ministers also involved the indefinite notification regime and specifically focused on the application of the indefinite regime of the absence of any review. Perhaps I can just give you some paragraphs in relation to that, rather than turning up. A and Scottish ministers at 3 tab 29. That bit is involved subject to an indefinite notification regime appears in paragraphs 1 to 2. The focus of the complaint on the absence of the possibility of review appears clearly from paragraphs 3 and the penultimate sentence of paragraph 6. And also appears in paragraph 12, where the judge is summarising the petitioner's submissions. Those submissions are then answered, as one sees from the summary of the respondent's submissions in paragraph 29, directly on this point, and then from paragraph 47 onwards, the issue is considered. We say all those authorities are directly in point, deal with the very scheme that we are dealing with, and do, we respectfully submit, warrant careful consideration. We respectfully conclude with the initiative.
I must say there's not a great deal of thought gone into, perhaps I'm being unkind, the Massey case, little 3. It's very brief. I mean, it doesn't really encourage me to think that they focus very precisely on the problem of the indefinite nature. I quite see that was the issue, but there's not much attention given to that feature of it. It's just rather saying the scheme as a whole is something that can be justified.
Well, yes, it appears that what they did was to rely upon the reasoning as applicable in their context. It was set out in Adams. Make the same criticism about Adams.
Yeah.
It was reasoning at a relatively broad level of generality.
Yes.
But nevertheless, it is reasoning which did look at the essence of the proportionality balance, considered on the one hand the impact on the individual, and weighed its likeness against the gravity of the harm and the nature of the duty on the state, and those were regarded by the Strasbourg Court as being the critical feature. So those doesn't express the level of detail which this court has been subjected to. The essence of the proportionality balance is Strasbourg government rules. Looking at the map.
Well, I'm just looking to see what the facts are, and it wasn't a particularly grave offence in Massey, was it? It was indecent assaults. Difficult to judge. Yeah.
Paragraph on page 4.
Yes.
16 countries.
Oh, I see, yes. Oh, I see, yes, it goes up to that, yes. Because one has the feeling sometimes the court is influenced by the facts of the case. After all, they're looking at the applicant, and they may have thought, well, this chap doesn't deserve very much sympathy for his situation.
To some extent, there is raises the same point as the government always has instructed. To the extent that they always say that determining the facts of the case before them, and it's all the context and facts.
Yeah.
Yes.
Yeah.
It is equally evident in a context like this that the nature of the challenge was to the structure, it was to the absence of
Yeah, certainly true.
and isn't something which is fact dependent. So,
Yeah.
it starts with the human element because it always has an impact, but at least analytically the structure
Well, this was obviously one of these historic sex abuse cases in Massey.
Yeah.
Sounds as if it's an institutional one.
Taking the points Ryan and the review rather more broadly or on a higher level of principle, a number of points can be made about that. Firstly, and perhaps most importantly, evidence, and evidence relating to risk. We've been through this already, in particular relatively briefly. The evidence as it exists currently suggests that risk persists for many years. And one simply can't state that one is ever in a position to say, certainly in relation to these more serious offences, that there is no risk. No risk. At best, the evidence is very uncertain as to the length of time for which some risk must be assumed to exist, if not in fact exist. And in those circumstances, in my submission, a precautionary approach is permissible in a scheme of this kind. The nature and seriousness of the harm and the relative lightness of the impact. Of course, if the evidence changes and either does reach the position where it can confidently say there isn't a risk, then Parliament can, of course, reconsider. We respectfully don't agree with the point that the Exchange had with Lord Phillips shortly before the short term. We don't agree with the respect of the lower courts. Saying what about the person who can turn up and establish a risk of no risk, if it doesn't reach that stage.
Well, I mean, you can think up people who are quadriplegic and things like that. And the question is, I mean, then I suspect you could say that there's no risk. I mean, the person can't move and so on. Now, the question is, how do you deal with those cases? Does one just say, well, of course, you can always think up things, but in remote things like that, but in that kind of situation, but one has to allow for that.
Even with those, I mean, one doesn't want to get into two extreme examples, but even with the case of a quadriplegic, the assumption, the premise is that the quadriplegic was convicted of an offence which warranted 30 months.
I was assuming he's become quadriplegic since committing the offence.
So, you've seen from the Forbes case that it covers things such as the downloading of pornography, which itself has the most serious effects on children, which one could engage in if one was quadriplegic or not.
Yes.
And the closest one comes to it is really the person in the coma.
Yeah.
You have to be unable to commit a criminal offence of any kind, at which point the solution it might be thought was
The prosecution's unlikely.
Well, he won't be able to get to the police station in person, will he?
And it's pretty difficult for the quadriplegic to do that either, really.
There are very, very, very few examples that one could posit of that category, if any. Legislation is
Broader than that.
The trouble with that, this sort of, the trouble is that there's no real analysis in the evidence about all of this, is there really, at all? I mean, to say of F that he would still, if he became a subsequent quadriplegic, there would be a risk from him, seems to me to be utterly far-fetched, absent some evidence. I can see it has a certain forensic attraction, your point, but to my mind, that's about it.
Well, what one can say on the evidence is that one can't can't exclude the continuation of this. And Parliament, in my submission, is entitled to take it.
But there's no suggestion that they've enacted it on you can't exclude the possibility of any risk, is there? Surely they're interested in real risk.
Well, I'm not sure I can make that assumption. They've set the scheme with no right of review for an indefinite period in relation to those most serious offences, recognising the relative likeness, engaging application, the regime and the seriousness of the harm. And in my submission, it can't be assumed that Parliament is thinking about a gradation of risk, a real risk, or something which could properly be described as that. One gets into all sorts of difficulties and territory. I can come on to some of them. How does one design the scheme if one wants to scheme at the moment? One gets into all sorts of difficulties. The moment one introduces the adjective, there are problems with application. The only basis on which the basis on which it could legitimately operate is some risk that could not be excluded. And those circumstances, particularly keeping the convictions alongside, make the regime effective.
I have a recollection, Mr. Eady, of, I haven't looked at it for a long time, a decision of the Supreme Court of Canada about something to do with an offence of importation of drugs or something like that. And what they say is something along the lines of, because it had a fixed sentence or something, which made it very absolute and rigid. And my recollection is that the Supreme Court said something along the lines that you can't invalidate a scheme or legislative scheme by dreaming up sort of remote exceptions, which then make the scheme unworkable or inappropriate or ludicrous, whatever you like. I just have a feeling that they don't.
It's not in the bundle.
No, it would go back. I think it goes back. It's not very recent. It goes back, I would think, before, but into the 1990s somewhere. I've forgotten what it's called. I'll try myself.
But the discussion is of some use because it illustrates the extent to which one has to go. Assume that the position is that Parliament was designing a scheme of this relative likeness to cover some risk. One has to go to a very extreme place to discover the exceptional example. And it is really the person in the code and not much else. Even the Fiji example is not a good example once one recognises the reach. So that's the position in relation to the evidence. Secondly, in terms of right of review, and of course I accept.
Well, there's evidence that a very significant proportion of sex offenders reoffend and that may reoffend 10 or 15 years later. Implicit in that evidence is also a very significant proportion of sex offenders don't. And where there seems to be no evidence at all is in relation to the latter category. There's assertions. I was just looking at what the Court of Appeal said about this at paragraph 44. The assumptions that underpin the provision are one, that there's a risk that those who have committed serious sexual offences may commit further sexual offences for the rest of their lives, and two, the notification requirements will assist the police in preventing and detecting. These two assumptions are falsified in a case where it is clear there's no real risk that the sexual offender will reoffend. No purpose can be served and so on. In our judgment, it should not include offenders who no longer present a risk of sexual offending. So there's just this implicit assumption that there are some without any evidence of any kind as to how you identify them. I mean, that's the problem, isn't it?
It is the problem, and it's put very extremely. It's put on the basis of a premise of the person presenting no risk.
Yes.
And the evidence, whatever else it does,
Yes.
whatever its uncertainties, which we've gone through this morning, whatever its opacity, on no view does the evidence establish that. On the contrary, the tendency of the evidence is to suggest long-term risk in relation to these.
Well, query long-term risk in relation to many of them. It doesn't exclude the possibility that there are some, and as a matter of common sense, some people who get sentenced to more than 30 years for maybe a single rape in particular circumstance may well, or will almost certainly, 10 years' time, not be at risk of reoffending, a young man who, when drunk, commits a serious rape that gets him 30 months, and 15 years later, he's grown up, he's married, he's got 4 children. Quite different from the paedophile, where you can say that that's an completely abnormal sexual propensity that psychiatrists show is one that is liable to persist throughout one's life.
Well, the difficulty that I have is that I'm not sure that even in the case of the example you give, you can confidently be said that the person has no risk. The young man who goes out and gets drunk and commits a serious rape and gets 30 months, he's gone out and committed a serious rape, albeit when drunk. And the fact that he's married and has got 4 children, does that reduce the risk that he poses to the 0 point?
Perhaps a better example is the one that's actually given by Ms. Cressati in her report, which may or may not be accepted, which is that intrafamilial sex offenders with female victims actually present a very low risk of reoffending.
Very low, and then one gets into the subject of the debate, which I deliberately didn't get into because it goes to and fro with no resolution, as to whether or not offenders are crossover. In other words, are there categories of people, or the others, as I call it, was there were some, who go from intrafamilial and then into non-familial sexual offenders?
Well, we were always being told in the family division that once you've done one sort of rotten, nasty sexual thing, it couldn't be shown that you weren't going to do it with other types of children and other types of victims and different ways and so on. We're always being told that.
I mean, what we may well say is that because you simply can't, in any individual case, choose between the sheep and the goats, statistically, there is, in every case, a risk that the individual will be one of the goats rather than one of the sheep.
Well, it does come to a point which I'm practically worth making now, which is, that was going to be my third point, we can take it as a second one and then come back to the second point, which is the nature of the review. And how does one go about setting it up? What level of risk is acceptable? And it's the point that my lord is on. If you've got a statistic that says 18.4% after X number of years, it rather follows from that there is some risk. There may be some sheep in amongst them, but it would be extraordinarily difficult to set up a scheme where you can confidently say that the protective aim is being properly and adequately met. However you set it up, so that a person's whereabouts would cease to be relevant. As I say, I've already accepted in the context of a parole board where detention is the consequence. They have to grapple with that, but they deliberately don't grapple with rather they should no risk. Risk and so on. And in the context of a scheme like this, could one set it up so there's no risk? My submission, yes. And the nature of the review that you would have to put in place does call into serious question whether or not one could do that.
Would it be for Parliament then to define or to set out what the test was it was to apply on the review, or could it be just left open so that
Query whether they could do. Because if you take my Lord Lord Phillips' sheep and goats example,
yes,
you're always going to end up with a significant risk at least because of the difficulties of judging when something's a sheep or a goat. But
yes,
you're always going to end up with the difficulty that you have some risk out there, and that is a risk which Parliament has evidently decided not to tolerate. If one was going to set up the scheme, someone has helpfully collected together some comparative materials, but they are very interesting because they go directly to the point that my Lord made. Some of them do, as far as I can tell. Some of them leave it rather more open. If the court judges, and a series of factors, time since offending, and so on and so forth, a list of factors. But at least one of them, in relation, I think, to one of the Australian territories, is set up on the basis that the court is satisfied that there is no risk. And if that is what you're doing, and if the evidence is as it currently is, but one could never be satisfied about that, other than in the theoretical example, because there are sheep and there may be goats, or the other way around. If you can never get to that point, what is the point of putting the scheme in place? So there are serious issues about that. As as I say, most of those issues do feed back into the question whether one accepts that because of the difficulties, there will always be, well, it's an alternative proposition, it's either there will always be some risk, or, Phillips puts it, you may theoretically end up with a person who is no risk, but the difficulty of solving issues can go to, in effect, insuperable. Or, as near as makes no difference, insuperable. To the point where Parliament could legitimately conclude that it was not prepared to take that risk, and not prepared to set up a scheme. But it is of some interest to at least address, in the context of proportionality, what that scheme might look like. And that then does lead one into questions about whether or not it would be acceptable to set up a scheme that says no risk. Well, if so, what's the point of that if I'm worried about the state of the evidence? And if it's something less than that, you do immediately get into my second or third point, which is that you necessarily undermine the effectiveness of the protection by setting up a scheme in that manner and in that form. It's what Lord Bingham in the Animal Defenders case called an excessive discretion. I think the concept he used. He was considering whether or not an alternative scheme could be put in place with less, in a less dramatic way with the broadcasting restrictions. He said, well, I'm not going to go into that for a whole variety of reasons. And the third of them was because any scheme that he could conceive which might replace it would end up inevitably being cast in terms of conferring an excessive discretion, which I think he meant that the person who was left with it would almost inevitably end up on the wrong side of one line or the other. And there is some force in that point in the context of our scheme. Animal Defenders is at 430, tab 1 tab 31.
How does the scheme minimise or prevent reoffending other than through deterrence? Because all you're doing, all the scheme does is to tell the police where the chap lives. Now, if he's a paedophile or whatever, the mere fact that they know where he lives, I suppose might be some factor, but what impact it really has on the risk, I don't know. I'm not sure that any of this work really grapples with that. I mean, there are a lot of general statements, as Mr. Justice Kerr's judged, but there's very little analysis of that. I mean, I can see that it may be said, well, people are likely to be deterred from committing offences because the police know where they live, and I can see that it may help subsequent detection. If you're trying to stop it.
Yeah, it's prevention that you're concerned about. I mean, one could,
which is presumably what you are really trying to do, is to stop it.
I mean, one could take similar facts to those in the Thorpe case. The Thorpe case involved a married couple who had been convicted of serious sexual offences with their stepdaughter. They'd been released from Northumbrian police, and they then moved into a caravan park in Wales, and the Northumbrian police were able to provide information to the caravan park owner because it was judged that was impending, and there would be an influx of little children. Appropriate to release that information to the caravan park. Now, I think in that case, concerns had been, as it were, almost accidentally raised by the caravan park owner with the local police, who then started making inquiries. Gives you an illustration of the sort of practical impact that it could have if you know the whereabouts of the offender. It does enable the police to keep track of them. It does enable the police to... There are a number of schemes which are ongoing, which I described very briefly earlier on, about the possibility of releasing information in relation to their children by a particular individual. So there are a variety of ways in which it would be helpful to know where the individual lived and where he was based.
Do we take account of these travel orders and things as well?
And related travel orders also. I in essence, the answer is any practical step that one can envisage the police take in the use of the information. Prevention. I'm not sure the other way, but one could proceed on the basis that one could never find an example of a potentially thoroughly useful preventative use for information. Indeed, one could put it rather higher than that, perhaps, if one recognises that the police already have in their power information about conviction and sentence, so on, in the future. It might be thought that information was of considerably less use to them in terms of prevention and so on. Less use to them without the wraparound of where this individual is. So, due respect to the state of the evidence is point one on my review. Then one has the nature of the review, how you go about doing all the points I just made in relation to that. And I fully accept that this is, as it were, a related point, a consequential point, perhaps. It comes back into the discussion premise on which the court of appeals operated, and if you assume the premise, certain consequences follow. But certain consequences also follow if I'm right on risk and my first response, because you would inevitably compromise the effectiveness of the scheme in circumstances where a risk does continue to exist. If you create that mismatch between the whereabouts and the retained conviction information, for example, there is also the problem in terms of compromise of risk, which is perhaps worth putting some weight on, of fluctuating risk. And again, it goes to the terms. Let's assume, for the sake of argument, that one has an individual who has been released, and the individual knows that he is subject to this regime, the police are keeping tabs on him, the authorities effectively know where he is. He is therefore, to that extent, engaged in oversight by the authorities. No doubt he is, as part of that, as part of his process, at some points at least, engaged in supervision. If you lose track of the individual, so that he is no longer on your radar, it might be thought that there's a commensurately greater risk that he would go off the rails. He might fall into bad company again. He might be tempted where otherwise he might not be. And again, the evidence is unclear as to whether or not the risk is just a simple straight line descending, or, as seems inherently much more likely, whether it is dependent upon outside influences, outside factors, the exposure to temptation, the exposure to risks and bad company, and so on. And all of those things are not assisted, to put it at its lowest, by losing track of them.
Of course, that suggests that if you have a mechanism for removing the register, you would need to have something to get them back on again. Is that not right? I mean, you may find your judgment was wrong.
That I think is right.
No, I quite see that normally you would expect a conviction to follow, but there are circumstances where you wouldn't want to wait for that.
Quite. I mean, there is certainly that point which can be tacked onto this one, but it posits a much more worrying situation, which is if you accept the fluctuation of risk, the serious harm which this whole scheme is designed to avoid may well have happened before you get there. And there are finally, on this aspect at least some serious practical and resource issues. Those were at least relied upon in part by the House in Essen Marpa, where Lord Steyn described the possibility of an individual right of review as leading to the possibility of interminable and invidious disputes. And it's right at least to note some of the numbers that are involved. I referred you to them earlier on. in the appendix at page 129, paragraph C, as at the 23rd of December 2008, there were 20,505 people on the indefinite scheme, including 13,000 who are in the community. In other words, not in detention somewhere. And today that figure, I think, has unsurprisingly increased, and it is now up at, I think, around about 22,000 or nearer 23,000, giving you round numbers, and 15,000 odd in the community.
What was the earlier date?
The earlier date was 23rd of December 2008. It is, of course, right to acknowledge that young offenders are also subject to the indefinite regime with no right of review. Parliament evidently considered their position with some care and decided that was the appropriate course, no doubt for substantially the same or similar reasons. I, of course, acknowledge as a general proposition that the criminal justice system has in a variety of ways treated juveniles differently from adults, even where, for example, they commit serious crimes such as murder. And Lady Hale in Smith, by reference, I think, to an American judgment, indicated, Smith is at bundle 3, tab 19, indicated a variety of reasons why that is so, and that it is appropriate broadly to treat them differently. In my submission, however, it doesn't follow that it's an inappropriate or irrational judgment for Parliament to make to continue to subject them, or those of them who are convicted of the most serious offences, to this continuing regime of notification. The scheme, as we saw this morning, already differentiates and makes allowances for young offenders. It does so in relation to the periods for which the finite periods for which they're subject to the regime, and it does so implicitly, if not expressly, in the uniform 30-month leads to indefinite notification period, because 30 months for a child is going to be a considerably more serious conduct than 30 months for an adult, in summary. H and the Queen. And in my submission, the principles and the approach from the broader criminal context, for example, in Smith, the tariff context, can't simply be transposed into this sort of context. The notification scheme is no part of the sentence. It's simply the consequence of the sentence, whose aim is prospective and protective. And on the state of the evidence, at least, the no risk point, or the no continuing risk, and all the points I made about the difficulties of setting up some sort of scheme and the consequent potential serious harm to the efficacy of the protective aim, apply just as much to those who are convicted when they are under 18 as it does to those who are convicted afterwards. Lord, my lady, two authorities that I should refer to, and they are, first of all, MARPA in Strasbourg, where, as my lords and my lady will be well aware, Strasbourg, as Lord Scott put it, I think in the L case in the course of argument, didn't disagree, but they reached a different view to my lords in the domestic judgment. The Strasbourg authority is at bundle 6, tab 53. The context will be well familiar to my lords. I'm not going to go through the underlying facts again. As I'm sure you will be well aware, it involved the retention for an indefinite period of inter alia DNA on the database in relation to those who have been acquitted of criminal offences. And the key passages in the judgment are, first of all, between 101, or perhaps 102, and 104, page 20, top right-hand corner. Where the general principles are set out, and in particular, in the context of this case, it is to be that the paragraph 103 is to be noted. And in particular, the sentence halfway through paragraph 103 that reads, "The domestic law should notably ensure that such data are relevant and not excessive in relation to the purposes for which they're stored and preserved in a form which permits identification of the data subjects for no longer than is required for the purpose for which those data are stored." In relation to the first of those, which was obviously, those were regarded as thoroughly important as one sees when one tracks on into the section dealing with the application of those facts. First of all, in relation to the data not being excessive for the purposes for which it is stored, that obviously gave rise to very specific problems in the context of acquittals, particularly in the context of acquittals for a whole range of offences. Any recordable offence was the scheme that was being considered there, whereas here no one has suggested that the content of the information called for under Part 2 is not necessary in order to enable effective monitoring of those who are convicted of these sorts of serious sex offences. In other words, there plainly is, and I think there is accepted to be, a clear and pressing link between the content of the information that is provided and the legitimate aim which our legislation pursues. So on no view are we in excessive territory. Secondly, the data mustn't permit identification of subjects for longer than required for that purpose. A not too long point as opposed to the not too much point. That brings one straight back into the arguments that we've already been through for and against indefinite regime for the most serious offences. As I've emphasised, uncertain evidence, no point where risk-free, dealing with those convicted of the most serious offences, a precautionary approach is justified. The problems that were identified in Essen-Marper with the domestic regime for retention in that case flowed, in my respectful submission, as one sees from the paragraphs in which the analysis is conducted, and the particularly relevant one is paragraph 119. That is the core reasoning of the court. But you see from 119 and the paragraphs which then feed back into it, as it were, that the problem was created by a unique combination in that case of the following features of the domestic regime. Firstly, it applied to those who had been acquitted. Secondly, it applied to any recordable offence. Thirdly, it was indefinite. And fourthly, it applied irrespective of the age of the suspect. But it was that combination which created the problems. One can't simply take out bits in isolation and say, therefore, no indefinite regime, therefore, if it's young, that's the end of it. It was the combination that caused the trouble. And there are,
And it applied to people whether or not they've been prosecuted, as long as they've been arrested.
It did. Yeah. It did. But there are, I mean, the differences hardly need pointing out, but it may perhaps be worth a quick spin through the differences so that it's clear. At every level of that, each of those four, there are significant differences. As to the first of them, those people who are acquitted were plainly not so here. The importance attached to that fact by Strasbourg in Essen-Marper is evident, for example, not merely from 119 but from 122 as well. Not so here because they've been convicted.
Yeah.
And that's critical.
So the last little four lines of 119 are really met, actually, in our case, because you've got, in effect, defined criteria because you know the seriousness of the offence that's been provided for. You're not dealing with previous arrests, but you've got the special circumstance of the conviction.
Yes. And I'll come on to that in a bit more detail because it feeds into a French case which I'm going to have to deal with called Bouchacourt. And that is a section which is picked up and dealt with in that subsequent case. But it's just dealing with the differences between the situation in Essen Marper and here. Conviction, not acquittal. As to the second one of them, which was the any recordable offence, not so here. Recognised that, indeed, I think in Essen Marper they specifically recognised, it was part of their reasoning, that there was a difference between Scotland on the one hand and England on the other, or England and Wales on the other. You see that from paragraphs 109 and 110. But you'll note the contrast that they pointed up for this purpose between Scotland on the one hand and England and Wales on the other. And in the present context, it's to be noted that Scotland is held up in Marper as the shining proportionate example because it restricted those who were acquitted to those who were acquitted of serious sexual offences and violent offences. Here, a fortiori, because we're dealing with people who are convicted of precisely that type of offence. So not merely is one not dealing with the vast category of any recordable offence, one is dealing with a very specific category of offence, serious sexual offending, and one which has been recognised as such in the contrast between Scotland and England that you see in 109 to 110. As to the third of them, indefinite, it's to be noted in relation to paragraph 119 in Marper that this is very squarely, the indefinite nature is not a problem in its own right, it's very squarely linked into the fact that it also applies to any recordable offence. And here, as you will need no reminding, scheme only applies to the narrow, serious category of offences where the case for protection is very strong given the harm that will flow. Even within that, the legislation carefully calibrates the scheme, distinguishing between periods on the basis entirely legitimate, we submit, of the seriousness of the offence, and it's only indefinite in relation to the most serious. As to any age, a point which the court returned to in paragraph 124 of its judgment, it's a point I've already touched on. But again, the scheme here applies only to those convicted. It takes account of the young person's position in all the ways I've indicated, making due allowance for it in the statutory scheme. And nothing is said by the court in Essen Marper that suggests that where you've been convicted of a serious offence, you can't have a notification regime applying to young people for a limited, or in some cases of real seriousness, indefinite periods. Bouchacourt is the next authority, and that is at Bundle 6, tab 55. And having seen my learned friends, Mr. Owen's submissions on this case, one is tempted at least to ask the question, argenteratum locutum, in the words of Lord Roger in AF number 3. But on this occasion, at least, it has a question mark after it, and I'm rather hoping it isn't the conclusion. A variety of things to note in terms of the status of this judgment. It isn't yet final. There is a period within which either party can apply to the Grand Chamber for a reference to the Grand Chamber. Here, the application, if it was to be made, would obviously be made by the claimant. That period is in Article 43 of the Convention. Secondly, it is a chamber judgment, and it isn't in the Grand Chamber. And there is therefore still at least some room, even if this goes to the Grand Chamber, for the court to be assisted by my lords and my ladies' views on the issue in our particular context. And you'll need no reminding that if the position in Strasbourg is ultimately relatively uncertain, it might be thought that there is a more powerful case for the sort of dialogue that the court has talked about on a number of occasions. If Strasbourg is going to damn the regime, let Strasbourg damn the regime, in short. And whatever else may be said about this case, it has to be set alongside and considered with Adamson and Massey, which you've already seen, which are directly to do with the very thing that is the core of the challenge in this case and concerns our domestic regime. And my submission is that the UK cases are in favour of the acceptability and the proportionality of the scheme. You will also note the relevant findings of the court start at paragraph 56. Paragraph 56, perhaps the only point to note in relation to paragraph 56 is that it does, to some extent at least, draw the sting from the Court of Appeal's point about Adamson and Massey not having, on their view, not having directly raised the precise complaint about no review in the indefinite regime. It makes the point that Strasbourg can pick up findings of violation from the facts given, or as they appear to them, from the papers before them, and they don't need to wait for the parties to raise a complaint. Indeed, I think in this case, Article 8 was raised proprio motu anyway by the court. You'll see that this scheme, this French scheme, involved a notification regime as well. I confess on our side of the court, not entirely sure how that system worked. The relevant article, or the most relevant article, appeared to be Article 706/53/10, and hopefully my version of this isn't page numbered, but it's, if one starts with the first page, with the judgment page, it's 1, 2, 3, it's on the fourth page in. They summarise the relevant domestic law, and 706/53/10 you'll see about a third of the way down the page. So there appeared to be some right of review, potential right of review accorded to an individual under French law.
Well, that's relied on quite considerably by the court in its findings, isn't it?
It is. And that was the purpose of taking you to it, to show you what it looked like. But you'll also note that the court has cited Ibbotson and Adamson and so on in paragraph 38, amongst other things. and again in paragraph 65 of the judgment.
Yes, Mr. Eady, we've just passed 4 o'clock.
My lord, I'm sorry, I'm not going to be very much longer. So.
No. When we resume tomorrow, there's one point I'd like some help on. If a sex offender receives an IPP, what is the test for releasing that offender?